Clifford location. And if you do, sir, that'll be a violation of your bond, and you will end up back before a judge in Taylor to address that.
And
so thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose this.
I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know. I will hold you in contempt of court and I'll have you arrested. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now.
Where's the bill of particulars?
The bond is being, the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to the jail now.
Why am I being arrested?
Take her down to the jail.
What crime have I committed?
Just stand right in front of that warrant.
Oh, looks like HP is in the waiting room too. So we'll bring him in. All right, good morning, sir. Give me one moment.
Good morning.
Highland Park. Oh, is that Officer Monroe? Hello, Highland Park. Okay, we're gonna wait. Your name, sir, for the record.
I'm up your Roman Susticate Trust legal fiction corporate entity defendant. That's what you want. I am one of the sovereign people.
Yes. Okay. All right. So this is for Eric Joseph Martin. And officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay.
I object to that any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase RIC of the capital M lowercase ARTIN family, one of the living people living on the land, not the corporate entity defendant.
Okay, sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people of the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P86378, appearing on behalf of Mr. Martin, Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the bat. I'll move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the U.S. Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a U.S. Supreme Court case. Defining probable cause is fact sufficient for the belief. There is no fact for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault.
Mr. Martin.
Hold on.
Mr. Martin.
It's kidnapping.
No. What we're going to do, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm going to entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
It's arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just going to set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because see, the officer filled out the complaint form. He's lying
Yes.
by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't even be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of my due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been
Okay,
arrested.
but
I should be here now. The charge is dismissed. There is no evidence here.
talk
And
over me,
actually,
Mr. Martin.
my
Mr.
sister
Martin.
had been caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed her.
That's
So she
enough.
really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9074 Clippard in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2 a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Man, they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're going to have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process right. I can't live there because she makes up a lying allegation. I do not lose that right. That's my right.
You have a pretrial that's scheduled for June the 23rd. You have a pretrial scheduled for June 23rd at 9 o'clock. There is a no contact provision and you cannot return to the Clippard location. And if you do, sir, that'll be a violation of your bond and you will end up back before a judge in Taylor to address that. So thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is dismissed now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave the state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human right. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habit that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. You're going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done.
What is her name? Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer. Take care.
Thank you, Your Honor. I appreciate it.
No, come on out. This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory council is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now. Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a class 5 felony. This is in violation of ARS 28624C, ARA.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why are they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them, is the microphone off, Louis, by the way? Turn it on.
Excuse me, that's illegal. Y'all can't do that.
No, that's on now. Turn it
Yes,
on.
it is, Justin.
All right. So the offenses are non-dangerous. I'm finding them
Why are you allowing that?
I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to.
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch, yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count.
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge
Hold on,
that.
I'm sorry. I'm getting, what's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up? You're not, okay.
Because I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement.
All right, stand by. Apparently they're gonna restrain her and bring her back in. Thank you. All right.
This is what y'all brought me in here for?
All right, defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement,
I didn't run from no police.
and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. There's separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing. Y'all being a legal The court lacks jurisdiction over the subject matter. Y'all don't have no right, get this shit off of me.
If I could have just a second, Your Honor.
I ain't never been fighting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-7-708?
Yes, I'm sorry, ARS 13-708.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victims present. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight.
A sovereign citizen argument may focus on jurisdiction, but sentencing operates on established convictions and applicable rules. Here, the court is no longer deciding whether the defendant accepts its authority. It is calculating consequences from convictions, enhancements, and prior release status.
Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the second degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. This court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5. The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the costs of an attorney to represent you on appeal. That will include the costs of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay. You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence. What? Hold on a second. What?
How much time did he give you? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you all very much.
Take a seat
I have a question.
in this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down in that blue chair.
Do I have the
Sit
same
down.
rights there?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options. The plea...
No,
what you've
I do
just-
not recognize
Well,
anyone
I'm-
in this court.
Okay, well,
I
that's
don't
too bad.
recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it? Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She's in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something, and
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed that.
Well, your documentation that you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official, in this case, who is acting as a public servant, to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
while
did.
asking.
I exited the courtroom and asked a police
Who
officer,
is-
probation
Who has
officer.
the indemnity bond?
Uh,
Where is the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed, you're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest.
Stop fighting.
No, this is a false arrest.
Okay, relax.
This is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarocci.
Well, hello everybody. How you doing? So I went to court today for a bench warrant to deal with a bench warrant that was put out for me, allegedly because I didn't make an appearance in court, but I did turn my paperwork in for that. You're allowed to turn in paperwork. You don't have to physically go to court. Paperwork is the same thing as making an appearance. However, they struck it from the record that I made my appearance. They struck the recusal of the judge from the record, and on top of that, they sent me a letter and they stated that I wasn't who I said I was, that I am who they say I am, which when I asked questions about that, the judge yelled at me and told me he didn't have to answer any of my questions. And then when I asked for the bill of particulars and the indemnity bond, I was arrested and taken into custody and held against my will. And so that's a false arrest. But not only was that a false arrest because it's all based on fraud in the first place, but secondly, they didn't read me my rights. I wasn't read my rights by the judge in the court, and I also wasn't read my rights when I was arrested. Also, they did not tell me what my charges were. So there's that. I can't wait to get the paperwork where they tell me what they're charging me with. So this is all because of the right to travel. Okay? It's all based on the right to travel freely, unencumbered, and unfettered according to the Constitution. Now, I'm going to pull up some stuff for you because people need to know what the truth is, and they're not going to really know unless I actually physically show them, because you guys, you're not going to do the research, right? You don't really care. You're just going to tell me I'm crazy and nothing that I say makes sense. You can replay all of this later because it's alive now, but they hold it up for 30 days, and you can write down all of these things if you want to. There's benchmark cases that all deal with all of this stuff, but we'll start with Ohio Revised Code. I was threatened with retaliation for threatened and retaliated against. They were trying to coerce me into basically doing business with the state of Ohio, which I don't have anything to do with. I'm not a state of Ohio resident, okay? Under section 2905, hold on, let me flip this around. Ohio laws and administrative rules, section 2905.12, coercion. No person with purpose to coerce another into taking or refraining from action concerning which the other person has legal freedom of choice shall do the following: threaten to commit any offense, utter or threaten any calumny against any person, expose or threaten to expose any matter tending to subject any person, or hatred, or contempt, or ridicule, or damage any person's personal or business repute, or to impair any person's credit. Institute or threaten criminal proceedings against any person. Take, withhold, or threaten to take, withhold official action, or cause to threaten to cause official action to be taken or withheld. Okay, so anyways, you guys can read all of that. That's the section you need. Because that's what happened to me. I am a non-resident alien, according to 5301.254. Okay? You are a non-resident alien unless you are a U.S. citizen, but I'll get to that in a minute. You have the right to the bill of particulars of your case, which I asked for, and they did not give me. And when I asked for it today, and for the indemnity bond, I was arrested. This is the location of the debtor. This is UCC. Do you know who the debtor is? I do. Hold on. It's this. The United States is located in the District of Columbia. They are the debtor. Any foreign bank registered and licensed by a state, which would be all banks, all courts are banks. The United States business. It's a corporation, a partnership. Also, the United States citizen is a corporation or a partnership with the District of Columbia. That's 15 U.S.C. 4724E. Here you go. 18 U.S.C. 911, citizen of the United States. If you claim willfully and falsely and represent yourself as a citizen of the United States, you are going to be fined and imprisoned, or both. You can only be a citizen of the United States if you are a public servant dealing with the law, so governors, senators, judges, cops. They're all United States citizens. You are not. Under Ohio Revised Code 4507.04, non-resident exemption. Non-residents are permitted to drive upon the highways of their own state without, right here, without. Bam. Wake up. Here you go. So not only do you not have to have a license, according to 28 CFR 29.10, owner withdrawal from the program. Owner withdrawal from the program. The owner may withdraw from the program. This is for a registration. So you do not have to register your car if you are not engaged in commerce. Under common law, you don't have to. You can withdraw from the program at any time. It's voluntarily. You have to remove the decal and change the license plate. You cannot have a Ohio State license plate. You have to have your own personal, private license plate. You should go through the Department of Transportation, or you can get your own whatever, or just not even have a plate at all. Just remove it completely. Everybody needs to be doing this. We all need to recognize this. The more people who do this and realize what their rights are, the more rights you have. Right now I'm fighting by myself. Everybody else doesn't have the guts or the balls to do it. I don't know what to tell you. It's not my fault or problem. Here you go. Other things related to the case. Take a screenshot of this. These are the laws, codes, statutes, regulations, case law. I also have the constitutional law in here. But they're doing all of these things unlawfully. Look at that. Look at that. Right here. Citizens of each state shall be entitled to all privileges and immunities of citizens of the several states, ensuring equal treatment of travelers. You are not a driver. You are a traveler. Affidavit of truth. Affirmation of rights. All of this. Take screenshots. Look these up for yourself. Find it out. This is me doing a public service announcement for all of you. So now more people can start doing it. We need to take down Admiral Maritime Law. It's the law of the dead. I'm not dead, are you? This is my public service announcement for you. I was arrested. My friend was there with me. Her and her friend were with me. They witnessed it. Everybody that was there witnessed it. Say hi, Erica.
No, I look like crap.
But I have witnesses, which they'll be subpoenaed eventually, and they'll be able to confirm that my rights were violated. They didn't read me my rights. They didn't tell me my charges. It's called robbery ashore. It's called piracy. Because they're in Admiral Maritime, and I'm common law. They're pirates. And committing treason. So there's that. So, just an FYI, the government's not your friend, and they're not here for you. You have to know your rights, and you have to exercise them. I'm still learning the policy and procedure part of it, but I know the law.
Okay, the court is on the record in City of Conneaut versus Amber R. McHenry, case number 24 TRD 527. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. We may have a resolution of the matter, should the court be willing to accept it, whereby the city would dismiss the fictitious plate charge at defendant's cost, and Ms. McHenry would then enter plead guilty to the two remaining charges of failure to reinstate, driving under suspension, and expired plates. The city would then recommend whatever fines the court would deem appropriate along with the court costs of the case. Thank you.
Thank you. Mr. Sayage.
Thank you, Your Honor. I did convey the offer from Law Director Lewis to my client, Ms. McHenry, after extensive talks and going over what she would be waiving today. She has decided today that she would take the plea offer along with the state's recommendation of just court costs and fines.
Okay, Ms. McHenry, it's my understanding today that you wish to change, you originally entered no plea to charges of failure to reinstate an unclassified misdemeanor and expired plates, a minor misdemeanor. You wish to enter guilty pleas to those two charges. In exchange for those guilty pleas, the fourth-degree misdemeanor charge of fictitious plates would be dismissed at your cost. Is that what you would like to see happen today?
I believe so.
I understand by pleading guilty to those charges that you would be waiving your right to the jury trial that is currently scheduled at the end of the month, as well as all of your trial rights. We just had a trial last week, so you kind of know what a trial is like. So by pleading guilty to these two charges, you'd be waiving all of those trial rights. Is that what you wish to do?
Would that put an end to litigation?
Yes, it would.
Let me know.
I'm sorry?
Yes.
Okay. Also, you are represented by Mr. Sayage. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes.
Okay. I do find that defendant's pleas of guilty to these minor and unclassified misdemeanor offenses in subcase A and B, failure to reinstate and expired plates, to be knowing, voluntary, and intelligent. The court will accept the guilty pleas to those two charges, and I will therefore find her guilty of those offenses. I will dismiss at the defendant's cost the fictitious plates charge in subcase. So Ms. McHenry, I did not impose community work service. I could have. I did not impose a Class 7 license suspension. I could have on the failure to reinstate charge. I've just given you a fine and costs, although I'm ordering you to provide proof of insurance on the vehicle you're driving that day. If you're not able to provide to the clerk proof of insurance on the vehicle you're driving that day, you are subject to what we call a non-compliance suspension with the Bureau of Motor Vehicles. I guess what I'm saying, Ms. Kennery, I could have sentenced you in a much more severe way. I did not. But understand that if you're back here with similar offenses and you're found guilty of those, I will impose those. What I didn't do today, I would do at a later time.
State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
No.
All right, state may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, You have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court. So I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
I'm not threatening you. Say one more word and that's 30 days. 30 days!
Across these proceedings, the central problem is not simply unusual legal language. It is the decision to substitute a personal theory of law for the procedure the court is actually using. In the first case, the defendant believed the accusation should be dismissed immediately because he disputed the evidence. But the judge explained that the probable cause issue could be challenged through the preliminary examination, where the accusation could actually be tested. The court even explained the possible outcomes. If probable cause was not established, the matter could be dismissed. If it was established, the case would continue. That distinction is critical. A courtroom argument can be legally relevant and still be strategically mistimed. The defendant was given a recognized procedure for challenging the accusation, but continued treating the arraignment itself as the place where the entire factual dispute had to be decided. The second case shows the same strategic problem at a more serious stage. The defendant had failed to appear for a scheduled trial after receiving notice. A warrant was issued, and when she later appeared, the court was dealing with that existing warrant. Her demands for bonds, accounting, and other sovereign citizen concepts did not replace the procedural reason she was before the court. The warrant was executed, and she was taken into custody. Then the Kansas case demonstrates what happens when the court reaches the evidence stage. The defendant chose self-representation and was explicitly told that she would have to follow the same procedural and evidentiary rules as an attorney. The state then presented evidence of several probation violations, including a positive drug test, an admission, failure to report, failure to complete treatment, and failure to report law enforcement contact. The court found substantial violations and revoked probation. The common thread is simple. Legal consequences follow the procedure, evidence, and orders recognized by the court, not the defendant's preferred definition of jurisdiction. And that is where the sovereign citizen strategy becomes most dangerous. The more attention goes toward proving the system has no authority, the less attention remains for the actual legal pathway that could change the result.